Oh, okay. You can still hear me okay, right? Yeah. Okay. Hey everyone, welcome to today's presentation, update on pay transparency laws. We're going to give everyone a couple more seconds probably. Once I see participant numbers kind of stop, we'll probably get going. We do have a lot to cover, so we won't wait too long, but I do want everyone who's planning on attending kind of being on before we get started. For those of you who don't know me, my name is Tawny Alvarez. I am a partner in Veryl's Labor and Employment Practice Group. My work with Veryl includes both advising clients on best practices concerning all things employment related, as well as representing them should they find themselves in the course of litigation. This presentation is being recorded and will be provided to you following the presentation, and you'll also be provided with copies of the slides. Unfortunately, this is a very detail-oriented topic, which means that the slides are full of information, and you will be provided with a copy of it, so you don't have to worry about furiously writing everything down as we move forward. Additionally, should you have questions, please place those in the Q&A box, and over the course of the presentation I'll try to answer them as I'm on the topic. You can also wait till the end and share them at that point, and with hope we'll have extra time to get to it. And if you have a question that I wasn't able to get to, of course you can always email me. My email is on this initial slide and also will be part of the slides and emails that you get after the presentation. So with that, we will get started. And Leah, if we can move to the next slide. So why are we talking about this topic? You're all here because you know pay transparency is important, but is it really just that we're looking at the pay transparency question, or is there more to it? And there's, in most cases, more to it. First, pay transparency statutes are primarily state specific. And when we say state specific, it's going to be based off of the jurisdiction in which the individual works, or a location where the applicant may have applied for the job if it was a completely remote job. And it could also be based off of locations in which you do business. So lots of different state rules are applicable. Following COVID, we've seen an increase in the number of organizations who have fully remote positions. They've been doing this in an attempt to increase the hiring pool, especially for very specific needs within their organization. Understanding regulatory issues that apply when you hire someone completely remote and the states in which they work in is really important. And from an advising standpoint, myself and my colleagues have seen an increase in these type of questions and also an increase in organizations that aren't following all the regulations that they should be. To make this even more difficult, however, this is an area of law that's quickly evolving. So many states have pending and recently enacted legislation, and we're going to discuss those a little bit kind of during today's presentation. Next, when organizations are transparent about pay, this can also reveal issues with past pay practices, which could serve as evidence of pay discrimination or a violation of state and federal equal pay acts. So as we figure out how to move forward with complying with pay transparency statutes, we also have to acknowledge and recognize whether or not we're opening ourselves up for individuals within our organizations or applicants to bring claims that there's violation of equal pay acts or other forms of pay discrimination. And then finally, having a policy regarding wage transparency and wage equality and best practices is important, but understanding risks that may attach to that transparency is really important. So during the course of the presentation, we're going to have some discussion about that as well. For those of you who have joined me in the past in presentations, you know I like to start out with, hey, this is where we're going. These are the things we're going to be talking about. So if you say to yourself, well, wait a second, I thought we were going to be talking about something completely different, you can start multitasking at this point in time. Otherwise, we're going to jump right into it. So Leah, let's get to that next slide. This is for our more visual learners, this is a graphical representation of much of what we're going to be talking about today. This is an image of state and local pay transparency laws. So our states in purple, New York, is a state in which there's both state and local laws that have been enacted. Our blue states have no law currently enacted, but some of them recently will be turning to orange, and orange are locations in which there are state laws that are going to be applicable to individuals. And then our yellow states are ones in which there may be local laws that have been enacted, but there aren't state laws that specifically are relevant. So when you see anything that says local laws enacted, so anything with this yellow or the purple, it's going to be important for you to recognize and make note when you hire someone that you're going to have to be mindful about what county or what city they live in to determine whether or not that local ordinance is applicable. Let's jump to the next slide, Leah. So first, which states have recently passed legislation? And in this last term, we've seen Hawaii, Illinois, and now Maine, who have recently passed legislation. And we're going to spend a little bit of time on Maine's statute. Maine's statute is LD 936. It was passed to be enacted and placed on the special appropriations table on June 8th. Right now, to be enacted, funding of approximately $90,000 would be required for the next 2 fiscal years. What it would require is pay transparency generally. Specifically, what does that mean? Employers with 10 or more employees have to ensure that any posting that they do for a job includes a statement that lists the prospective range of pay that the employer will offer to a successful applicant. Under the statute, range of pay means the range of pay that the employer anticipates relying on in setting wages for a position. This could include reference to an applicable pay scale. So between $20 an hour and $24 an hour. It could be based off of a previously determined range of wages for the position. So maybe in the past we have hired people at these different levels from a starting position. And then finally, the actual range of wages for those currently holding equivalent positions or the budgeted amount for the position. So range of pay is broadly defined, but it'll be interesting to see kind of how the Department of Labor, well, first, whether or not funding for this occurs. So right now, while it's been passed to be enacted, it hasn't been enacted yet. So it's unclear whether or not this will go into effect later in the year, and it won't unless there's funding kind of generally. As to proposed legislation, I'm going to spend just a little bit of time talking about the proposals under Massachusetts law. The proposal in Massachusetts is similar to any of the individuals who are present today who have over 100 employees who are making regular yearly EEO-1 filings to the federal government. What the Massachusetts law purports to do is to create a similar standard at the state level, where employers who have 100 or more employees would have to make a report to the state concerning demographic information and wage rate, wage range as to different positions. So those are our locations that have recently passed some form of legislation or who have proposed it recently. If you have individuals who are working in Oklahoma or West Virginia or some of these other states and want to get a better sense as to what that law looks like, just shoot me an email and I'm happy to provide you with the legislative number of it so you can get a better sense and talk to your lobbyists if you're interested in speaking to them about those acts. Leah, let's jump to the next slide. So, in discussing what the main purported legislation would look like, what's been passed but has not yet been funded, I mentioned the requirement in many pay transparency situations as requiring states to post, states that require employers to post salary in the job posting or ads. This image gives all of you a better understanding of states that have pay transparency laws that are going to require some form of salary posting in a job. There could be situations in which some of these states are colored that weren't colored in the last map. In a lot of situations, job ad pay transparency laws are looked at separate and apart for broader attempts to regulate pay transparency with employers, kind of limiting ability to talk about, to limit discussions about pay rate or how much individuals are making. So this image shows salary ranges that are required to be included in job ads. So Colorado, California, Washington, New York, some bills that we're still awaiting to be signed. You'll see Illinois and Hawaii. And in the last slide, those have been passed and they're waiting to take effect. And then other states that have bills pending in the legislature. Leah, let's turn to the next slide. So as we're talking about this, I think it's important to understand from a New England standpoint, what different laws are applicable and kind of underlie these pay transparency rules. So under Maine law, we actually have two bills already and two standards that go and fall within pay transparency rules. And one of them is Maine's equal pay law, and then the other one is a salary history band. And recently, this term, actually, Maine equal pay law was expanded. So previously, Maine's equal pay statute only protected individuals from discrimination or unequal pay on the basis of sex. This term, however, it's been expanded to also protect individuals on the basis of race. So employers can't pay individuals on account of race or sex, non-comparable salary or wages if the work on the jobs have comparable requirements relating to skill, effort, and responsibilities. you'll see that language comparable requirements, that phrase is not defined. So is it exactly the same or comparable requirements is something I see as we move forward. We'll see more litigation concerning what comparable really means. Employers can, however, pay at different wages for things that are outside of sex or outside of race. And that could include things such as prior experience, time in the position, how well they do the position. Additionally, under Maine's equal pay law, employers cannot prohibit employees from disclosing their own wages or asking other employees about what their wages are. This requirement is parallel to the National Labor Relations Act and Section 7 rights that employees have as to discussing terms and conditions of employment, but this provides state-specific rights as well. Additionally, Maine's salary history ban, people will recall that went into effect in 2019. Specifically, an employer cannot use or inquire about compensation history as to an applicant or prospective employee during the course of the interview process. They can ask about past compensation after an offer of employment has been made with wage and salary and compensation information included in it. But these are both kind of forms of pay transparency rules and regulations that underlie some of the new regulations that are being proposed more generally. Let's jump to the next slide and talk a little bit about Massachusetts, New Hampshire, and Vermont's equal pay laws. So in Massachusetts, employers can't require that employees refrain from asking, discussing, or disclosing their wages or other employees' wages unless the individual is in human resources or a supervisor or someone whose job responsibilities allow them access to this confidential information concerning pay. So there are restrictions on it, but more generally, you can't tell employees that they can't talk about wages, similar to the National Labor Relations Act. In New Hampshire, similar, you can't require employees to refrain from discussing the amount of wages or ask them to sign a waiver or any other document that could deny them the right to disclose their wages, salary, and paid benefits. For individuals who have confidentiality agreements with employees in New Hampshire, you should be mindful about this provision and make sure that you've carved out and have language that says that no aspect of this confidentiality obligation is meant to diminish or otherwise decrease rights under New Hampshire's Equal Pay Act or to foreclose rights under the National Labor Relations Act, kind of more generally. And in Vermont, Vermont's equal pay law also does not allow employers to restrict employees from disclosing their wages or ask them not to talk to other employees about their own wages. Additionally, kind of Vermont's language within the statute itself goes slightly further and says employees simultaneously, however, don't have any requirement to talk to other employees about what their wages are. So they can't be treated adversely if they refuse to share what their wages are. Vermont also has a disclosure provision within its equal pay law. So under the employee disclosure provision, employers aren't required to disclose employees' wages in response to inquiries from other employees, unless failing to disclose the wages would count as unlawful discrimination. So it's almost like saying, hey, if you know that there's discrimination occurring and you're being asked for wages about two individuals performing comparable work, then that could be a violation of the statute by failing to provide that information. I haven't been faced with a situation in which that's become an issue, but you should still be aware of it. With that, we're now going to really jump into the different state rules. And we're going to start with the state that we identified on the image that has both state and local ordinances. So New York State's pay transparency rule went into effect on September 17th, 2020. Will go into effect on September 17th, 2023. Apologies, I'm pushing everyone ahead. And it's going to apply to anyone who employs 4 or more employees. What it's going to require is that, an employer must disclose compensation or compensation range and the job description if it exists when advertising a job, promotion, or transfer opportunity that'll be physically performed at least in part in the state or will report to a supervisor or work site in the state. This is really important because if you have some supervisors who are working in New York, but the other employees do not work inside the state, you're going to have to comply with this requirement if you have 4 or more employees, right? So this New York State statute is broader than many of the other statutes that we see because it's not just concerning where the employee themselves physically performs the work in the state of New York, but also if they were report to a supervisor in New York, or let's say they work in Vermont, right? But they're remote employees, but they are for internal purposes or for payroll purposes, their home base is considered to be New York. Since the work site is in the state of New York, this would then become applicable. There is language concerning commission only positions. And in those situations, you need to disclose a general statement. The compensation's based off a commission. When we talk about compensation range and the importance and the necessity of including compensation range in the job ad or posting, that's been defined as the minimum and maximum annual salary or hourly compensation range that the employer believes is accurate. So I've had some clients who have said, well, can I say like this job pays between $27 an hour and $100 an hour? And here you have to believe it to be accurate. So is there a likelihood that you would pay $100 an hour, or are you just putting that in to hopefully attract more people to the position? That's what they're going to be looking at to determine whether or not you have put an appropriate compensation range within the job ad. Additionally, however, while statewide legislation goes into effect in September, there's already local laws that are in effect in New York. So if you have employees in Albany County, if you have 1 or more employee, they're an employer under the statute. And as of February 13th, 2023, you need to include minimum and maximum salary or our hourly wage for posted positions that are going to occur or could occur in Albany County. Again, though, you're going to have someone who's already working in Albany County. Similar Ithaca. Ithaca is covered if you have 4 or more employees who are working in Ithaca. Oftentimes I'm not seeing this with clients, but if so, if you have a group of employees right now in Ithaca, you should be looking at their local regs to determine the additional obligations that you have. Let's go to the next slide and talk a little bit about New York City. So the New York City pay transparency rule already is in effect. It covers employers who have 4 or more employees or independent contractors in a 12-month period. So it might be that like you had two employees there for 1 period of time, and then you had 5 employees there. If you had 5 employees in that location in New York City during the course of a 1-year period, this the New York City statute is going to be applicable to you. And what you need to do there is you must state the position's minimum and maximum salary and advertisements for job promotions or transfer opportunities. And it's going to extend from the lowest to the highest salary that they believe that you as an employer believes you would pay for the job promotion or transfer opportunity. Similarly, Westchester County, right above New York City, also includes a pay transparency rule that applies if you have at least 4 employees, unless of those 4 employees, 2/3 of them are family members. I'm not going to go into a ton of detail about the Westchester County, but if you have employees in Westchester County and in New York City, what I would recommend is that you be complying with the New York State. You begin complying with the New York State requirement now, and be aware of the city and Westchester County expectations in so much as there might be promotion or transfer opportunities that you also have to be complying with internally. We're going to move out of New York and we're going to talk about a couple of states that have local ordinances. As I mentioned, the slides are going to be provided after the presentation to everyone by email. So don't hustle to write down all these rules and the number of employees, because you will be getting this. And one of the reasons I did do so many words on the slides, and I apologize, was with hopes it would be helpful for everyone to kind of use as a resource later if they were to make a hiring decision in Cincinnati, in Toledo, in Jersey City. So in Jersey City, in New Jersey, if you employ 5 or more employees or independent contractors, then when you provide notice of jobs, promotion, or transfer opportunities, you're going to have to provide information concerning wage rates that you're paying. In Cincinnati, we're looking at 15 or more employees within city limits. In Toledo, 15 or more employees. Like I said, I presume there's not a ton of people on the calls who have these number of employees in these locations, but if you do, jump back to these slides so that you get a better sense as to these rules. Let's jump to California, Leah. So as everyone knows, and as we've talked about in the past, California is often one of the more progressive states as it relates to employee rights, and that's no different when we're talking about pay transparency rules. So under California statewide ordinance, effective January 1st of 2023, job posting requirements apply to an employer with 15 or more employees. And you're likely saying to yourself, "Whoa, good. I have 1 employee in California, but I don't have 15, so this doesn't apply to me." Unfortunately, however, only one of those employees has to be located in California. So anyone on the anyone who's listening who has 15 or more employees in general, but only one of them is in California, does have obligations under California's pay transparency rule. Now, it only applies, however, to individuals who apply for a job posting if the position may ever be filled in California, either in person or remotely. So let's say that you have 1 employee in California and you have 25 employees in other locations across the country. And those other 25 employees are all in person, and the only remote position you have is in California, and you are planning that you are going to hire for another position, and that position is going to be located in Massachusetts. In that situation, if it's in person and it's going to be in Massachusetts, you wouldn't have to include information concerning pay scale, but you need to be aware kind of more generally of your responsibility, because if there's any chance that the position could be done remotely, or that you would hire the position remotely, and I apologize, not could be done, but that you would consider the position to be hired remotely, then you are going to have to comply with California's ordinance. You're going to have to provide a position's pay scale and job postings and to third parties that use it to announce, publish, or otherwise publicize job postings. The pay scale is going to be defined as salary or hourly wage range that they reasonably expect to pay for the position itself. Now, California is different because of how it works with the 15 or more employees more generally, but only one needs to be in California. A lot of people would probably think, okay, that's probably the worst statute. And when I say worst, like most onerous to comply with. But interestingly enough, the most onerous to comply with is the next one we're going to talk about, and that's in Colorado. So Colorado was one of the first states that really adopted pay transparency rules. It went into effect January 1st of 2021. Last year, we saw Tesla, Charles Schwab, and a number of other very large organizations that received citations from the Colorado Department of Labor, indicating that their failure to comply with Colorado's pay transparency rules would result in fines and other citations. So what's required under the Colorado ordinance is that an employer who has anyone in the state. So if you have one individual, one remote individual who works out of Colorado, the Colorado state ordinance applies to you. And what it requires is an employer must disclose a position's hourly or salary compensation or compensation range in job postings, along with a general description of the position's benefits and other compensation. The reason why the Colorado statute is more onerous is because of this position's benefit language. So you can't just say like, and other benefits will be provided. You have to go into specificity about what those benefits are. So company sponsored health insurance is one aspect. If there's 401k match, what that would look like more generally, if there is an employee assistance program, if there's dental, if there are other benefits, reimbursement for, for not reimbursement, but if there's any type of kind of parking subsidy that's provided, those would all be considered benefits. The only ones that aren't included are things such as like coffee or snacks at the office or reimbursement of expenses that would otherwise be required kind of under federal law or tax code. But anything above and beyond that has to be listed in the job ad to better account for what those benefits are, in addition to that general monetary compensation. So the Division of Labor and Statistics does enforce this, and there is also relief that can be provided from an individualized standpoint if an employee is able to show violation of the law. Now, out-of-state jobs are excluded, but if there's any chance at all that the individual, it's a remote position and the individual could be in Colorado and they perform it, you have to be in compliance with the Colorado rules. So all of your remote postings, if it could be applied for by an employee or an applicant in Colorado, you would need, and you have one employee at least in Colorado, you'd have to comply with this statute. I have some clients who have set up job postings so that they can't be accessed by somebody who's in Colorado. It creates some really interesting, back end issues, and then also questions more generally. There's no requirement that an individual or an organization do business in every state. You could indicate to someone, we're not going to hire people who are in Colorado or Nevada or Arizona because we don't want to register to do business there and otherwise comply with it. But these are more general things that you need to be thinking about prior to posting for a remote position. Like it could be remote, but where is the individual located that you're going to hire from? Because you're going to have to pay unemployment, workers' comp, like you're going to have other obligations as it relates to those remote employees. And if you've attended prior presentations that we've given about this situation and about managing remote employees, you'll understand that there are more than just like, hey, this is where the person is. That you have to be in compliance with in starting that person out and in generally managing their employment. So if it is an out-of-state job, it's excluded, but employers don't have to disclose compensation if it's going to be performed entirely outside of Colorado. Even if there might be modest travel into Colorado, you wouldn't have to report it. But you need to be careful about kind of where the posting is occurring. The out-of-state exception is narrow because it applies only to jobs tied to non-Colorado work sites. Remote work that is performable in Colorado or elsewhere for a covered employer must comply with the act and the rules. Even if it states that the employer will not accept Colorado applicants, it still remains covered by the act and rule. That's the advice that Colorado's provided. So if you already have an employee in Colorado, you likely are going and are looking to hire people in a remote setting, even if you don't allow kind of people in Colorado to see the ad and you have it set up in that format from a back end standpoint, you still technically need to be in compliance with the Colorado wage transparency statute. We're going to jump to Connecticut, a location where it's more likely that some of the people kind of present today have employees. Connecticut also was at the forefront of pay transparency rules. Their rules went into effect October 1st of 2021. An employer is covered if it has one or more paid employees. What they must do is provide a position's wage range to an applicant upon request, or by the time the employer provides the applicant with an offer of compensation, whichever occurs first. So the employer must provide their position's wage range upon hire, a change in the position, or upon request. And wage range is defined as what the employer anticipates relying upon when setting wages for the position. And wages is defined as compensation for labor or services. The compensation doesn't, you can see this doesn't use benefits as part of the compensation. We can look at compensation broadly, and in some situations, benefits may fall within it. But at this time, kind of from a case law perspective, we're really looking more at the monetary aspect of things. However, anyone who's on the call who is involved in recruiting knows that the more that you advertise your benefits, however, that you're also going to see kind of an increase in candidates who are interested in the position, understanding that the compensation is more than just that monetary benefit. As to remedies, an employer that violates this requirement can be sued in a private right of action by the employees and also by applicants for compensatory and punitive damages, as well as attorney's fees, costs, and other remedies. We have a question as to if you have someone who's not officially remote, but is choosing to be remote for a short period of time, such as they live in Maine, but are visiting Florida during the winter, do these rules apply? I apologize because I'm going to give that horrible lawyer answer. And the answer is it depends. Depending on which state it is and for how long the employee is going to be in that state, determines whether or not you have obligations to register to do business in that location, and then also to provide workers' comp and unemployment in that location. And that's going to be a state-specific determination as to whether or not the individual is quote unquote employed in that state based off of that period of time. If someone's gone for 2 weeks on vacation and they're checking emails or attending meetings, in most situations, you're not doing business there. But if someone's in Florida for 4-6 months a year, I think there's a higher likelihood that you're going to be determined to be doing business in that state. And you should be mindful of the obligations that you have under their state employment laws, under their workers' compensation laws, under their unemployment laws. We're going to jump to Maryland now. So in Maryland, their statute became effective October 1st of 2020. And an employer is covered if they engaged in a business, industry, profession, trade, or other enterprise in the state. This one doesn't have, a number requirement. As if you're doing business in the state of Maryland, you're going to have this obligation. And what it provides is that an employer must provide a position's wage range to applicants for employment only when requested. So there's no requirement that it be posted. You just have to be able to respond to that question when it's asked. So you couldn't push the discussion down the line when you have an applicant. If they were to call and say, how much does this pay? You would need to respond to that request, even if you didn't plan to hire the individual. Let's jump to Nevada, Leah. So in Nevada, all employers, if you're an employer, so you have one employee in the state, you're covered by the requirements, but there's nothing that makes the requirements applicable outside of the state. So if you're posting for a position that's going to be performed in Nevada, the position's wage or salary range or rate to applicants who interview for the position must be provided. And also this is applicable when an individual is being considered for promotion or transfer to a new position, or if they interview for or are offered a promotion and they request the range or rate of pay. So most of that is if there is a request made, then it would need to affirmatively be provided as opposed to placing it in the advertisement. A little closer to home, if we jump back to Rhode Island, I probably should have done this geographically, moving from like closest to home and further away, but we did it alphabetically just because kind of easier for me in my mind to keep track of. Rhode Island's ordinance just went into effect on January 1st. If you have one or more employees in Rhode Island, an employee is defined for purposes of the unemployment statute. So that 28-14-1 is part of Rhode Island's unemployment statute. And there, an employer must provide a position's wage range to applicants for employment, but it's upon request. So it's not there in the ad itself. Also, however, the wage range is the range that the employer is going to anticipate relying upon in setting wages for that position. That anticipation means that there might be changes in the future, but it should be a fairly solid estimate as to what you think it's going to be. And so employers in Rhode Island also must provide employees with the wage range at the time of hire when they move into a new position or just generally upon request. So if someone came in and said, I want to understand what the rate of pay is for my position, like where am I in that range? You would have to provide kind of the general range as to what you would pay for that position. And some of that may be higher than what you're currently paying people. It may just be the range of what you're paying people who are currently in that position. Wage means compensation, all compensation for labors or services. So that's going to include, bonus potential, monetary benefits. And honestly, I would throw in the other aspects of benefits. So the 401k, the health insurance, in so much as you can like put a monetary value onto those things. If we jump to the other side of the country, if we jump to Washington, an employer is covered if it engages in any business, industry, profession, or activity in the state, and it employs 15 or more employees. So there, it's important that you provide the position's minimum wage or salary to the applicant if they request it. And if they offer a transfer or promotion to the employee, the new position's wage scale or salary range has to be provided upon request. And the definition of postings means solicitations to recruit applicants for a specific position. And it's going to include the necessity that you include both discretionary and non-discretionary wages and benefits as part of what the definition of compensation is. You see that like some of these statutes do a really good job of defining what compensation is and other statutes don't. When you are working with applicants in multiple applicants or employees in multiple jurisdictions, my recommendation would be to read compensation most broadly so that you're not picking and choosing in each location, because what that's going to do is create a record, likely that's going to live online for an extended period of time, of very different ranges of pay or rates and compensation. And this actually leads to our last slide, which is something that we're going to take a decent chunk of time on. For individuals who have attended presentations I've given in the past, you'll laugh because usually we're like with 2 minutes left and I still have 5 slides and I'm trying to rush through it. But really one of the goals of today's presentation was to give an underlying understanding of the different states, how varied their obligations are, and then to talk some about pay transparency policies, because the risks that are created by failing to account for or to put significant time and effort, consideration, and thought into pay transparency policies is likely going to lead to larger risks within your organization. So if it's not already something that is on your radar and on your agenda, it's something that you definitely need to be speaking to your operations and finance teams about. You as your HR team, like your HR, finance, and operations will all need to be working together as it relates to this. So pay transparency policies, the first step is kind of what we just started doing right now. Review your legal requirements, assess where do you have employees, where do you have work locations, do those states currently have pay transparency policies in effect, and what do they look like? Okay, let's say that you operate only in states that have no pay transparency policies. At that point in time, you may want to be looking at some of these other states and saying, gosh, in the future, it's likely that my state's going to see pay transparency policies. What would that potentially look like? If you're confident that you're not in a location that's going to see pay transparency policies, it becomes a cultural question. We're seeing more and more companies who are affirmatively taking steps to advertise pay rates, and other benefits that are available to applicants and to employees, with the hopes that this practice is going to increase the level of applicants they have, and that culturally it's going to result in individuals kind of staying and increasing longevity with the organization itself. A big part of this kind of dialogue is, what are your goals and objectives? So are your goals and objectives simply to comply with state and local law, or is your objective to increase candidate flow? Is it to increase I don't want to say value, but the strength of the candidates who are coming in, and with hope that that would then increase longevity and tenure with the organization? From there, we're going to draft policies. And in drafting policies, we're going to consider what is compensation. What do we as an organization define compensation as? And it can include things that are, I don't want to say more touchy-feely, but that are more difficult to put a financial value on, but that you think is a part of the benefit of being employed there, whether or not that's monthly lunches, or whether or not it's some type of stipend to do activities, whether or not it's 3 paid days off to do volunteer efforts in addition to health insurance, pet insurance, those type of benefits that your organization may specifically provide. So you're going to want to figure out, like, what is compensation in our organization? Are we going to be transparent about pay at all levels of the organization, or is it only with regards to specific positions? I highly recommend that if you're considering a pay transparency policy, that it is throughout the organization and that you're not picking and choosing which organizations which positions within the organization, because I think it's going to lead to issues concerning kind of how that's viewed, how third parties view, like, well, why is certain information being shared and other isn't? Is that because it makes significantly more or significantly less than all these other positions? What's the employer trying to hide? Those type of questions. When we're doing that when we're deciding what we want our pay policy to look like, we also have to perform an audit as to our existing pay practices. So looking at different positions in different locations and determining, are individuals who currently hold this position paid fairly? Do we have an equal pay concern? Is there a tremendous difference in the rate of pay within the department? And if so, is that explainable? And is it explainable based off of non-protected reasons? So things such as experience, tenure with the organization. What we often see when we perform these type of audits are situations where individuals who have been with the organization for an extended period of time are making less or equal to what some of our newer employees are making, just because of how the market has shifted and the increases that we need to make to attract and retain talent. In those situations, we have to be ready to pivot and to increase the salary of other individuals, because outside market shifts, it isn't going to be in and of itself sufficient to support why there's pay disparity, especially if there's gender or race that is a part of the analysis, as in the individual who's been here for the last 10 years, who's making the same money as someone who has no experience who started this year, right? That's going to be concerning. And if one individual is a man and the other one's a woman, or the individuals are of two different races, that comparator information is going to be highly prejudicial in any audit from an administrative agency or in a lawsuit from current or former employees. So when we're drafting the policy, we need to kind of do this audit and determine if pay alterations are necessary. At the beginning of this slide, I mentioned the importance of getting finance and operations involved. The last thing I want to hear is that we're doing an audit, and when we go to finance and say, like, we need to make some changes, that we're told that there isn't budget for that, because that's going to create bigger issues. In doing these audits, I highly recommend that you do it through counsel, because then if you find concerning information, it's privileged. If you find concerning information and you haven't done the audit under the guise of privilege, if you're sued in the future, that data is going to come to light, and it's going to show evidence that there was this point in time in the past where you became aware of wage disparity that may or may not have been related to gender, race, or another protected class, and that despite having that knowledge, you didn't do anything. And saying it wasn't in the budget is not going to be a valid defense to one of those claims. When we're doing this audit, pay alterations may become necessary. And if they do become necessary, designing and executing communication plans are really important, because you're going to have to explain, why are we suddenly giving this tremendous increase? How long has this individual been underpaid? It's going to open up their eyes to a possible claim that they might have against the organization based off of historical underpayment. Additionally, it's important, let's say that you do the audit and you don't find that any pay alterations are necessary. You're still going to want to have a good communication plan that sets forth culturally why you're choosing to be transparent about pay and what that means for the organization. You're going to do this in launching the policy. Internally, this is going to be more of a dialogue, because when I say launch, applicants don't really care. Like, suddenly they're just going to see applications that have the pay range in it. They're going to appreciate that more. You may see a change in the quality of applicants you're getting. But when I talk about launching the policy, really we're talking about internal communications as to what that looks like. And then finally, kind of with policies and practices such as this, continuously auditing is really important. Being mindful of the evolution of positions, the people who hold positions, different reporting structures. All of this is really important to make sure that we don't operationally evolve in such a way that pay doesn't simultaneously match job duties and functions of individuals who are performing these jobs. Now, certain organizations who may be federal contractors or federal subcontractors, or generally kind of have an OFCCP affirmative action program, already should probably have many of these aspects in mind as we see an expansion of what OFCCP kind of is looking for and requiring as it relates to different positions, their range of pay as to those position titles, and then also gender, veteran status, race, and disability status, because those are all also factors that we're going to be looking at and trying to analyze as we move forward in performing these pay transparency audits. So we have a couple of questions in these last 5 minutes, so let me take a look at those and then we'll go from there. So the first one is, we're a Maine-based employer who has employees in New York and Massachusetts. When we post our positions, our location in the posting will show as Maine, New Hampshire, Pennsylvania, and remote. Due to having employees in New York and Massachusetts, are we required to advertise wage range in accordance with New York and Massachusetts state law in the posting if there's a chance that we would hire in those states? So in New York, since you only have one employee, not 4, then you would not have to, because you have to have 4 in New York. I do have some clients though who are choosing to comply because we're still waiting for further guidance from New York State as to how they're going to read that statute as to location of employees, because sometimes, and in this situation right now, the New York statute is broad as to location. So from a New York standard, since you don't have 4, arguably you wouldn't have to apply, but you need to be mindful that if the individual could be employed in New York, you now have 2 or more individuals there. As to Massachusetts, you're going to have to be in compliance with the Massachusetts equal pay law, and then they don't have specific rules concerning advertising the wage rate. So it'd be more whether or not you choose to comply with the New York advertisement of wage rate because positions could be performed remotely. If it has to be performed in Maine or Massachusetts, then you would not have kind of an obligation to post for wage rates there, post wage ranges there. We have another question, which is if a company is engaged in business in Maryland and has an applicant for a remote position from Maine, who requests a wage range, is the employer required to disclose the range, or is the employer only required to disclose the pay range to applicants based in Maryland? For that one, there becomes some interesting jurisdictional questions as to whether or not Maryland has a significant enough interest in the Maine applicant in order to use its power to say our laws apply to this individual in Maine. Most likely, though, what the Maryland court would say is because you've chosen to do business here in Maryland. And when I say do business, I don't just mean like sometimes we sell a product there, but that we're a corporation, that we, pay taxes, and not just sales taxes, but like we operate there in Maryland, that they are likely to say that Maryland law is applicable. Again, I always hate it when I have to say it depends. In this situation, I would provide the wage range to the employee if they're requesting it because we're based in Maryland. And if part of it would be, is the work going to be in Maryland? Like the person can be in Maine, but if the work's going to occur in Maryland, then you definitely should do it. If it's only going to apply remotely, I think it's harder to argue that you need to provide it. But recall that if the individual is calling you from a Maryland line or a Maryland email address, or they just changed their address to indicate that they were in Maryland, then you would have that obligation. And I've had multiple situations where I've received a resume that shows one location or address for the individual, and come to find out they actually have like multiple homes and they're living in one of those other homes at the time. So I'd be mindful of that. We have a question as to how this works with a collective bargaining agreement. So we include wage in the posting, but the collective bargaining agreement determines the wage regardless of longevity of the position. A new hire will make what an incumbent makes regardless of race or sex. The collective bargaining agreement is going to overrule the equal pay laws because that's been bargained for. So I would not, for those of you who have collective bargaining agreements that set for what the rate is for these different positions, I would be less concerned about the equal pay laws in the jurisdictions in which you operate. But you still have to be mindful that from a pay transparency standpoint, even if the collective bargaining agreement doesn't provide that you have to post the rate, you're going to need to be doing that. So it is 10 o'clock. I have a couple more questions. I'm going to keep running through some of these questions for people. You're welcome to stay. Again, this is being recorded, so you're going to get a copy of the recording if you have to jump off. But otherwise, thank you everyone for your attention. We're going to keep answering questions. If you need to jump, thank you again. So the next question, would you recommend adopting a policy and practices that complies comprehensively or checks all the state specific boxes and roll it out for all positions all the time across the board? Is there an approach that ensures compliance, even if it means making disclosures for positions or in states that don't yet have pay transparency laws? This is a big cultural question. If we're talking about resources, I think that the easiest way would be to do exactly what has just been suggested, which is find the most comprehensive state and use that as a basis for creating your pay transparency policy. I do believe that over the course of the next 5 years, we're going to see a vast majority of states that are going to implement these type of policies. And we're also going to see more and more regional locations. So counties and cities that are going to implement these type of rules. I also see with the progression of remote workers that this is going to be necessitated in order to remain competitive generally in the market in attracting and retaining employees. At the same time, however, if you're an organization that only does business in one state, you don't have a business model in which remote work can occur, you don't foresee yourself participating in remote work at any point in the future, that's likely overbroad. What I would then look at is history in the states surrounding your location. So if you're in Maine, look at what, Massachusetts has prescribed, what New Hampshire is considered, those type of other states. Also, having an understanding of what Maine's accepted but not yet funded statute looks like, and using that as a basis. Thank you all for all of your attention over the course of this. This is a really big and ever-changing topic. I mean, even last night as I was preparing for today, I was double checking, like, has there been funding? Now do we have a Maine transparency, wage transparency law, and those type of questions? But definitely something that should be at top of mind on your radar moving forward. We'll go to that last slide, which just has my contact information on it in case you have additional questions. And thank you again for all of your attention, and I hope you have a wonderful rest of your day.